Mr. Dumont?
Thank you, Mr. Chief Justice, and may it please the Court. As Mr. Fisher has said, if Mr. Riley had been carrying physical photographs in his pocket at the time of his arrest, there's no dispute that arresting officers could have looked at those photographs to see whether they contained evidence of crime. Now, what would have been reasonable in that situation does not become constitutionally unreasonable simply because Mr. Riley instead carried his photographs in digital form on a smartphone. The shift to digital format does not make the photographs any less his papers or effects.
In one of our court decisions in the past, a series of justices asked or noted that many of our rules were based on practical considerations. Practically speaking, a person can only carry so much on their person. That is different because carrying a billfold of photographs is a billfold of photographs. It's, anywhere from 1 to 5 generally, not much more. But now we're talking about potentially thousands, because with digital cameras, people take endless photos, and it spans their entire life. You don't see a difference between the two things. What has now become impractical. A GPS can follow people in a way that prior following by police officers in cars didn't permit.
We certainly see a distinction, and we certainly see the possibility that in some cases there could potentially be a constitutional difference. What we don't see is that in this case, on the facts of this case, or anything like it, and like the ordinary case, there is a constitutional difference from those phenomena. The theory,
by the way,
the theory, even if I'm carrying only 5 photographs, or if I'm carrying 2 letters, as was the case in the Chiagos case, for instance, that then Judge Cardozo decided in the 1920s, they are likely to be very personal, very private photographs. So I'm not sure that the expansion of volume increases the invasion of privacy.
Mr. Dumont, on your argument, and on the Solicitor General's principal argument, too, a person can be arrested for anything. A person can be arrested for driving without a seatbelt. And the police could take that phone and could look at every single email that person has written, including work emails, including emails to family members, very intimate communications, could look at all that person's bank records, could look at all that person's medical data, could look at that person's calendar, could look at that person's GPS and find out every place that person had been recently because that person was arrested for driving without a seatbelt. Now, that strikes me as a very different kind of world than the kind of world that you were describing, where somebody has pictures of their family in a billfold. Doesn't it strike you that way?
I think the answer there, one can always think of marginal cases where there might be concern. It is not the core case.
I don't know why this is a marginal case.
It is not the...
Your argument and the Solicitor General's principal argument applies to any arrest, and it applies to everything on a cell phone. People carry their entire lives on cell phones. That's not a marginal case. That's the world we live in, isn't it?
We hear that repeatedly. The facts of this case are not somebody's entire life on a cell phone. This cell phone had a handful of contacts. I don't think this is in the record, but what we understand is there were 250-some-odd contacts. There were about 59 photos, and there were perhaps 42 videos that ranged from 30 to 45 seconds, maybe a minute each.
The court is to make a rule not for this particular case, but for this category of cases. And I think what Justice Kagan pointed out is very nervous concern. That is, take an offense like failing to buckle up, even driving under the influence, not gang crimes, which is what we have in this case. It's your rule, then, that the cell phone is fair game no matter what the crime, no matter how relatively unimportant the crime. Is it all misdemeanors? All misdemeanors, and that opens the world to the police.
It is true that the court typically and properly in this area draws categorical lines, and that is what the Court said in Robinson it was doing. Now, it also is true the Court has repeatedly said that those lines are drawn based on the generality of cases. They are not drawn based on the marginal case or the hypothetical potential problematic case. Now, this case is in the heartland. It's a violent.
Well, Mr. DeMott, I guess what I'm trying to suggest to you is that you call it marginal, but in fact, most people now do carry their lives on cell phones, and that will only grow every single year as, young people take over the world.